welcome to another edition of Questions for Lawyers, Season 4. And for this episode, we delved back into Season 1 and got my second guest to participate once again, to sit on the hot seat, just like she's in Section 2, 1999, Nova Southeastern University Law School. It is my privilege to welcome my friend, Michelle Reichler, back to the show. Michelle, thank you again for doing this.
Thank you for revisiting my nightmares, and thank you for having me back.
I'm always happy to accommodate and give to people's fears and all that. That seems to be a specialty for me. But in any event, Michelle, I know I was talking with my parents recently, and it seems like every other conversation, they're talking about, well, now, you know, we have our wills, we have our trust, we have all these different things, and it keeps coming up more. And I think the reason is pretty obvious, that we're dealing with a pandemic in the United States, and close to 200,000 people have already died from COVID-19. Have you noticed that people have been more sensitive to those issues and asking you more questions about that?
So, you know, of all the times where this would be the most important thing to talk about, I have had an uptick in these kinds of, you know, document preparations, wills, powers of attorney, you know, estate planning type things. And it is more important than ever, especially now that these things get done in advance. But I just am constantly reminded that even in these crazy times that we're in right now, people are reluctant to actually move forward with going ahead and just doing this and getting it out of the way. So, you know, it's more important than ever that we do them in advance, because getting to people's hospital beds or assisted living facility beds right now is an impossibility. And so these kinds of things are more, you know, necessary than ever to contemplate in advance. But people just don't like to, you know, visit these issues. So unfortunately, I would like to see more of it, not just, of course, from a business perspective, but to safeguard people, because I have gotten calls. My dad is in assisted living facility. We really need a durable power of attorney for him. It's too late in the time of Corona, unfortunately, pretty much to do these things.
Well, I mean, death, sickness, taxes are some of the most unpleasant things to talk about. But what I always tell people is, you do it now so that you don't have to think about it when you're in a crisis.
I would think that that doing it would be a huge weight off of people's shoulders. But even my own father just said to me yesterday, I don't like to think about these things, but guess who's coming in to sign their documents? They are.
Well, that's good. That's good. Well, you know, it's not just something for our families. To anybody who's watching this or listening to this interview, this is one of the most important things you can take away from my shows. This is free advice you're being given. You are not being required to call the attorney to ask these questions. So you know what you're getting into the moment you pick up that phone and call Michelle or another estate planning attorney to get these things done. So again, that's the purpose of the show. And today I think we're going to delve into the documents that we're talking about that are most important for people to have filled out right now and done properly. Because if they're not done properly, what good are they, Michelle?
So to exactly that point, I recently had a client who, and exactly what you're saying, you don't want to use me? Please go use another attorney, because I just had an instance where someone took it upon themselves to do their own will it was done improperly, and now we have to jump through quite a few extra steps in order to make that valid in the state of Florida. So, you know, people ask me all the time, why can't I just use LegalZoom? Okay, use LegalZoom, but on the back end, it's going to be more time and effort for an attorney like myself to fix what is not initially done correctly. So penny wise, pound foolish.
Absolutely. And again, the cost of doing it in advance, when you consider the costs for probate, to probate a will or to deal with a situation where somebody dies without a will, I mean, the cost, I mean, what are we looking at if somebody doesn't have these documents?
Well, for probate in general, I tell people, just as a general rule, that you're not going to get out of a probate, most likely, I mean, this is a generic statement, for less than $5,000 for the costs of administration, filing fees, court costs, attorney's fees. And then if I'm able to do it for less, my clients are always going to be happier, right? So that's what I tell people. In certain instances, it can be avoided. Not in every case is it the best idea, but in a lot of cases, it absolutely can be avoided.
Well, let's talk about the documents that everybody should have right now. And if you don't have it, you need to get on it. The first thing I want to ask you about, Michelle, is a power of attorney. Now, why is a power of attorney important?
Well, first, people tend not to really even know what a power of attorney is. So a power of attorney is a document that gives someone else of your choosing the power to act on your behalf for almost anything legal or financial in nature. It can extend to some health issues also, but generally speaking, it allows someone to act as your attorney in fact, and more importantly, it's only effective when you're alive. After you pass, this document is obsolete. So really you're talking about only while you're alive. And it is in fact a powerful document, a very powerful document. The durable power nature of it means that it's in effect even while you are incapacitated. And actually, that's the most important aspect of it. You want somebody to be able to step in and act on your behalf, someone you trust, if you are incapacitated, to manage your affairs. Because without that document, the court has no choice but to appoint someone for you. So, and that comes in, the form of a guardianship, which is, as we've discussed in past presentations, a very expensive, court-involved process that absolutely can be avoided at the end of the day and should be avoided with this document. And just because you might have a spouse, that legally does not entitle them to come in and act on your behalf in almost every capacity. So you actually need this document. And it's important for someone who has just turned 18, and it's equally as important for someone later in life, because anything can happen.
Just to put it into practical context, Michelle, can you give some examples of what can be done with a durable power of attorney?
Well, a lot can be done. And
I don't expect you to name everything, but
yeah.
I'm just thinking like how somebody goes and gets a durable power of attorney. What type of things do they have the power to do once the ink is dry?
So it sounds like a lot because it is, and it's intended to be. But someone can go to the bank on your behalf, deal with the IRS, real estate transactions, Medicaid planning is something that was added to, to this document in a law change a few years back. Almost anything legal or financial, amending a will or amending a trust, changing beneficiary designations on your behalf. And you think to yourself, wow, is there really anyone I trust enough to do that? And people kind of have an issue with the durable nature of this. If I'm incapacitated, they want it to take effect when you're incapacitated, but the reality is that now it takes effect immediately upon signing. You sign this document and it's given to your person that you have designated to act for you, and it's effective immediately. That person can go to the bank today and clean you out. Now, they can, however, that would be a breach of their, obligations to you. We call that a breach of fiduciary duty. But honestly, if you're going to trust this person with all of these matters when you're not mentally capable, then why not, trust them presently? So that's usually how I get people to come around.
And that's an extreme circumstance. Most people are not going to go and do that. But, obviously there's bad apples and everything, as we know. But, the bottom line is it's not set up so that somebody can go and clean you out. What it's set up for is to allow somebody to help take care of you when you can't do it yourself, to look out for your best interests. So
Correct.
if you're in a good marriage, or if you have a son or daughter that you trust, you should not fear doing this.
No, because you're going to trust this person if you're incapacitated. Why not trust them today? And I'll give you an example of a situation where this document did not exist, and it was between a married couple, and a husband suffered a traumatic brain injury. There was no power of attorney. Now there needs to be a lawsuit settled, and in order to do that, because he lacked capacity and there was no power of attorney, the alternative, unfortunately, in that case was a guardianship. So now the wife has been appointed legal guardian over her husband, and that could have been completely avoided. So now there has to be a guardianship for the rest of his life.
And that will cost thousands of dollars, I'm sure.
Many, many, many thousands of dollars.
All right, well, I think we've covered the power of attorney. Let's move on to another document that matters while a person is alive, the designation of healthcare surrogate. Can you tell everybody a little bit about that?
Yeah, and a lot of times if you go to, a hospital or medical provider, if you're going to go for surgery, in fact, I just had surgery this summer, and the hospital asked me if I had this document and wanted to upload my own document. If you don't, sometimes they'll present their own to you. But basically what a healthcare surrogate does is it gives someone else the authority to receive your medical information and generally make healthcare decisions on your behalf in the event that you are temporarily, not permanently, temporarily unable to do so. So you're expected to, regain your ability to make your own decisions. And this document can give, timing aspects and decision-making authority. You don't have to give this person authority immediately. You can elect what timing you want. Maybe it's only when you're incapacitated. Maybe it's right now because you just want the other person to have that information, to access your medical records. My document also addresses organ donation and things like that. But if you have organ donation designated on your driver's license, that supersedes what might be in this document. But another very important, document. You want to give someone else the authority to make decisions and receive information on your behalf in the event that you're not able to do so.
Now, the designation of healthcare surrogate is with the hope that you're going to get better. Moving on to the next document, which is the living will.
Mhm.
And that's a document it's a very simple document, but it causes a lot of fear sometimes for people. And what that means for a living will is we're talking about making a determination of whether to pull the plug, whether to continue giving nourishment if it's a terminal condition. Now, everybody should have this document, but can you talk a little bit about what some of the fears are and why that's really not reasonable?
Well, and this document, I do a combination living will, healthcare surrogate.
Okay.
I think the misperception is, and I debate this sometimes with my colleague at my office, this is not like the movies where you are appointing someone to go and pull the plug in that moment. Really, it is a decision that you're making that says that you do not want to be kept artificially alive under certain circumstances. And you get to, depending on the document, you get to pick those circumstances. Do I have an end stage condition? Do I have a terminal condition? Am I not going to be expected to survive this? And you don't want to be kept hooked up to machines, kept artificially alive in perpetuity. You want to be able to, pass and move on without being kept artificially alive and breathing if there's really no reasonable expectation. So this actually is a decision that is made as long as you make that opinion known in a document such as this one. It is actually giving the authority between a treating physician and a consulting physician if you have in fact reached that point. And then the decision is really made between medical professionals pursuant to your instructions.
That's what I was trying to get at, because let's say, for example, somebody has a living will and, well, obviously they're in a position where they're not making decisions, but the family members are concerned about this one person being on the living will. And it's not just their decision. It's a medical decision made by not one, but two medical doctors that have determined that those conditions are met. Am I right?
Correct. And it's really you making this decision in advance what kinds of conditions you want to be present before that medical decision is made. It can be and they're all defined by Florida law: end stage, terminal. I mean, a lot of people have cancer, but that doesn't necessarily make it an end stage condition. I mean, a lot of people survive cancer. So, it gives you the authority to decide what kinds of conditions will be present before you want to be, I'll say relieved. But, given the, it's really your decision. And, this became much more, I hate to use the word fashionable when talking about these kinds of issues. But, going back to the Terry Schiavo case, which a lot of people in Florida know, and there was a battle between, the husband and the parents of a woman who really, was not ever going to recover from her condition. So this gives you the power in advance to make those decisions.
That's not just a famous case for Florida. I think throughout the country, people were watching that.
But of course it happened in Florida, so yeah. We're always special.
We set precedent on that, or at least we shined a spotlight on why it's so important to have that living will, because that was, aside from whatever position you were, it was brutal on that family. And it all would have been easier to, you never would have heard of the case had a living will been executed.
Correct. And it was painful to watch and public, and You know, all these things can be avoided by simple documents.
Exactly. Well, the one that people probably think about the most is their own will, their last will and testament. Okay. But this deals with your property after you're gone. So it's not a medical issue. It's not dealing with your property while you're alive or making decisions for you. It's when you've died. So why is it important for a person to have a will, and what does it allow? What does it allow the estate to do?
So a will only takes effect after someone has passed. And I'm going to dumb it down a little bit and just to say that, you know, there are pros and cons to things like wills versus trusts, which is another way to, you know, potentially, you know, dispose of your assets or leave your assets to someone after you pass. With a will, you know, you're talking about a court-involved proceeding afterwards. You're appointing someone, you're naming someone in advance to act as a personal representative. You might have heard the word executor. In Florida, we use personal representative, but you're appointing someone in advance. You're designating someone to, you know, have somewhat of a thankless job of distributing your assets pursuant to your wishes. Without that document, you're left to Florida law, which can determine the order in which people receive the assets. And therein lies the problem. Without you making these decisions in advance, it might go in a way that is completely against your wishes, is long and short of it. As far as the proceedings, you know, you're talking about will involving the court. You file a will with the court, and anything you pass away with that's in your own name, in order for it to get to whomever you would like it to get to, it has to go through a court-involved process. So I would think it's always better for you to wait, you know, you be able to make those decisions in advance for how you want your belongings and assets to go and to whom. A trust allows you to have a little bit more control. There are pros and cons, you know, to both, and it really is highly factually specific, and, you know, depends on your set of facts to determine which might be the best case scenario for you. A trust can be a living, revocable document that you can change, you know, anytime you want. A will, you can always do a new will, of course, and revoke the old one, but certainly, you know, most people do care at the end of the day how their assets are getting disposed of, and otherwise you're left to Florida law, and Florida decides who gets first, how much. Maybe you don't want your brother to receive anything. You know, after you pass, it's too late to make those decisions.
Right. Well, again, and you bring up the trust. The trust is something that people may not realize could be much more beneficial in the, you know, obvious, it's 100% guaranteed that none of us are getting out of here alive. So when that day comes, the trust can avoid a lot of additional issues that a will can't. Am I right?
Yeah, you know, a trust, if properly funded, and I give everybody, you know, funding instructions and things like that, it's a private document. It does not get filed in a court proceeding. That's number one. I mean, you know, a lot of times people wouldn't want, you know, a document like that to be public record, and that's exactly what a will becomes, public record. So, you know, a trust is a private document. It could be a living, revocable document, can be changed. It also takes effect immediately. So if you've designated a trustee, then that person can immediately take control over the assets and distribute them pursuant to instructions. You don't need to have a court put you in a position of authority. You have been named in a position of authority, and that document can be taken to financial institutions, presented, and that person can act. And sometimes there's a more immediate need for a trustee to have access, and if there's minor children, for example. A trust will allow that trustee, that person appointed, to immediately take control and provide for beneficiaries.
Let's talk about probate, because one of the major differences I know of with trusts and wills is what it will cost to probate a will. So let me first start with this. Ballpark range, what does it cost to do a will as opposed to a trust?
Well, ballpark. I think we discussed earlier, the cost of probating a will, and I generally tell people, after court costs and attorney's fees and things like that, regardless of complexity, really, of your circumstances, and it could always be more and it could always be less, I tell people, ballpark, expect that you're not going to get out of this short of $5,000 between.
That's if you're probated in the probate court.
Correct.
Okay.
You have to publish notice to creditors. You have to let creditors know that this person has passed. There are court costs. There's attorney's fees. Attorneys can charge in several different ways in a probate. They can charge based on a percentage of the value of the estate. They can charge for their time on an hourly basis. There are various ways that an attorney can charge. There's a lot to factor into that. It could be, when it's less, my clients are thrilled that it's less, but it can also be more. Interestingly, in the time of coronavirus, the courts are taking some shortcuts in hearings and things like that, and it's actually moving a lot quicker right now. Mm-hmm. But I have no doubt in my mind that things are going to eventually go back to normal, and it's going to take the standard 3 months to 6 months just to get open. But right now it's happening quickly. But as far as cost is concerned, and it can vary, you're talking about, single people, but you're talking about, upwards of $1,500 to do a trust, which also includes something called a pour-over will, which I always describe as a catch-all to anything that you might not have addressed properly in advance. So if you forgot about this account out there, that pour-over will act as a catch-all to catch that asset and put it into your trust. So you might end up needing a probate, but anything that's already in your trust is immediately accessible upon your death to the right people who you've appointed.
So let me put this in perspective. If somebody goes to Office Depot and does their will.
Ouch.
Well, let's assume that they get it right. Even if they get it right, they're basically passing a bill for $5,000 to the people inheriting their property. Am I understanding this right?
Basically, yes. Sometimes there are definitely sometimes where a probate is going to be necessary regardless of the fact that you have a trust. Mm-hmm. In cases where you might not have caught an asset, but yes, a funded trust, a properly funded trust, those assets are already going to be there and ready and able to be accessed by your trustee, the person who you have designated in advance. And it can be avoided, absolutely.
Michelle, you've given us a lot of your time today, and I really do appreciate it, but I have one more area I want to cover, which is during coronavirus, you have to have these documents signed. You can't go to the hospitals. You can't go to nursing homes. you've had to meet with people in person. Am I right?
Yeah.
And
You
how
know
do
what?
you, and given, I'm sorry, I didn't mean to cut you up, but given that you've had to do that, what type of precautions are you taking to make sure that your clients feel safe?
So what I'm doing to minimize contact is I do almost all of my consultations via things like Zoom, FaceTime. We can easily have these kinds of conversations virtually. An initial consultation, things like that. Ultimately, depending on the number of documents, and the fact that, Florida law requires witnesses and notaries to finalize these documents. Unfortunately, that is usually, for my purposes, going to require some kind of in-person meeting, because not only do you need to sign these documents, but many people make last-second changes, and I need to be able to be in front of my computer to correct your documents per your wishes. So usually it will require you to come into my office. Masks are required in my building and in my office, but we can do an initial consult virtually, but then an in-person signing has to be witnessed by two people, has to be notarized. But it gives me the ability to quickly make changes and, to get you on your way with your documents. Unfortunately, I do get calls for these, family members who might be in a hospital and want this done at the very last minute. And for people who might be in an assisted living facility, they're like, oh, my mom needs a durable power of attorney so that I can act on her behalf. If she has the mental capacity to even make that decision, I now cannot go into an assisted living facility or a hospital to assist with that. No one's going in these facilities right now. So I'm doing whatever I can to minimize contacts, but so virtual consult, in-person signing with precautions.
Michelle, this has been a very important conversation. If anybody is watching or listening to this, how can they get in touch with you?
My office number is 954-825-0398. I have a website, and I have received plenty of messages via my website inquiries, and that's reichlerlaw.com. And those are the two best ways to reach me, but I'm available via social media and my email, mreichler@reichlerlaw.com, and happy to talk with you and set up an appointment.
Michelle, as always, it's been a pleasure. I really appreciate you coming on here and educating the audience. If anybody has any further questions for Michelle, she's given you her contact information. If you would like to see a topic discussed on Questions for Lawyers, or would like to be a guest on Questions for Lawyers, call me, Jeff Adelman, 954-341-2777. Obviously, you can email me as well at jeff@adelmanlawyers.com. I appreciate you watching, listening, keeping the show going for now 4 seasons and over 50 interviews. We'll keep doing it because it's apparently very helpful to people, and I enjoy doing it. I enjoy educating the public, and I enjoy having quality practitioners like Ms. Reichler on the air with me.
I love that you do this, Jeff. I think it's such a great service that you're providing to people, even though it's really just the tip of the iceberg on a lot of these legal topics. It's really invaluable, and I appreciate doing it. And I've watched plenty of your other guests come on and give me an education.
Well, we've come a long way since the second show. So I think that at that time I was trying to go for this effect with the split screen, but I didn't realize it was going to be a year and a half later necessary for us to be in different locations. So, you're getting me in a much better spot than I was in March of last year.
Who knew we would all have to master the technology?
It's it's said so many times, but I'm very thankful I started doing this when I did.
Yeah.
I didn't realize I was going to be practicing broadcasting law come 2020. So, but in any event, have a good weekend, everybody. Please contact me if you have any questions. Be well.
Thanks, Jeff.